Mr. Chief Justice, and may it please the court. No party disputes Cooper's basic legal rule that absent a compelling interest, race cannot predominate in line drawing, even as a means to achieve a partisan goal. Here, the panel properly concluded that race predominated over partisanship in CD1's design based on strong factual findings, including that after map drawers moved more than 193,000 people in and out of CD1, its BVAP remained identical as in the 2011 map. In so doing, mapmakers sorted more than 30,000 Black Charlestonians based on their race, removing 11 of the 12 precincts with the highest Black voting age populations. This massive movement disregarded the least change approach that the state applied statewide, and that mapmakers admitted they abandoned only in Charleston County, which had been CD1's historical anchor. Disentangling race and party affiliation using the very methods this court accepted in Cooper, the panel credited the unrebutted expert testimony that race was a better predictor than partisan affiliation for the design of CD1. Under the clear error review standard, this court should affirm the panel's factual racial gerrymandering factual finding because it is more than plausible in light of the total of the record. Appellants also cannot show that the panel committed a legal error, particularly in its rejection of the alternative map requirement. Finally, the record here is indeed the inverse of Cromartie 2. Where a majority of this court determined that map makers designed a district using political voting behavior over time, rather than relying upon racial stereotypes. Here, by contrast, the panel found non-credible the appellant's assertion that they relied on merely 2020 partisan performance data for CD1's design. I welcome the court's questions.
Counsel, we normally have an alternate map in these redistricting cases, and of course we don't have one here. In these instances where you have a high correlation between race and political affiliation, how would you constitutionally disentangle them?
We have something we believe that was better, if not comparable, to an alternative map. We have this unrebutted testimony of Dr. Ragusa. That testimony is corroborated by the testimony of Dr. Liu. If you look at the amici briefs of the political scientists who performed the analysis in Cooper, they validate that the methods that Dr. Ragusa and Dr. Liu used are the same as in Cooper. All of the pot shots that are made by the defendants in their brief about Dr. Ragusa's analyses and Dr. Liu's, almost all of them, nearly all of them, and I can walk you through them, were made during either discovery or during Daubert motions or at trial, and the court simply didn't reject them. It is unrebutted evidence disentangling race and party, which is a form of circumstantial evidence, but akin to an alternative map. If you look at Dr. Ragusa's rebuttal report, figure 1, he charts out all the VTDs in CD1, and he looks at whether the racial composition or the political composition determines their placement in the map. And you can see that 4 of the 5 heaviest Black precincts were moved out of CD1. By contrast, only 5 of the 17 majority white precincts were removed from CD1. And this is, again, unrebutted testimony, and it serves the purpose of an alternative map because this court unanimously in Desert Palace said that there is no particular form of proof a plaintiff needs to show in an equal protection case.
Counsel, we have said that the burden that you're assuming of disentangling race and politics in a situation like this is very, very difficult. But it is your burden, right?
Yes, Your Honor.
And you're trying to carry it without any direct evidence, with no alternative map, with no odd-shaped districts, which we often get in gerrymandering cases, and with a wealth of political data that you're suggesting that your friends on the other side would ignore in favor of racial data. Have we ever had a case like that, with that combination? We usually are looking for those sorts of things, and we have those. Have we ever had a case before where all it is circumstantial evidence?
I racked my mind, and I think the closest we might come to it is a case like Gamillion, where plaintiffs would have lost there if they had been required to have proved by direct evidence, where the circumstantial evidence was overwhelming. But here, if you're asking whether there is direct evidence that the legislature admitted in the 21st century that they sorted voters on the basis of race as a means to achieve their political goal, no, we do not have that. But what we do have is the factual finding that the mapmakers had maptitude data with race data.
I understand that, and there's a lot of back and forth on it, and you certainly have the clear error standard in reviewing that. But we've never had a case where there's been no direct evidence, no map, no strangely configured districts, a very large amount of political evidence, whether the district court chose to credit it or not, and instead it all resting on circumstantial evidence. Circumstantial evidence to determine what we held as recently as in Allen last year is something that is peculiarly in the province of the states in drawing the districts. I'm not saying you can't get there, but it does seem that this would be breaking new ground in our voting rights jurisprudence.
Respectfully, I disagree. I mean, we have strong, this is not Cromartie, we have strong circumstantial evidence where we're not relying upon, the court did not rely upon foregone alternatives or conclusions about what happened. We have a racial target, that the fact that the Senate was proposing various maps over the legislative process and moving 193,000 people around, and they can only explain it as being by coincidence. The fact that the question in a Shaw case is whether there was a significant sorting of black voters on the basis of race. We have 30,000 Charlestonians moved out of CD1, out of their home county. It cannot be explained by least change, the priority principle that they said was guiding their map for much of the legislative process.
Sorry to interrupt, and that is to change the voting percentage in that district by how much?
Ultimately, it was by 1.36%, and Senator Campson used that 1.36%, the lead sponsor, to disclaim that this was a partisan gerrymander during the legislative process. So the court accepted that they had a legitimate means to achieve this political goal. We don't dispute that. The court accepted that they had this preference to bring in political counties. But what the court acknowledged is that when they brought in those counties, there were black people brought in alongside with them. That then led to an increased BVAP in CD1 that became too politically risky. And for the black people they brought in, they offset the black people by expelling them from Charleston County. And that goes to the heart of this court's jurisprudence of using race as a means, even for a legitimate political goal.
Well, it's not, just so I understand correctly, this is not a voting rights case, right?
This is
it's a gerrymandering case, right? And they did all of these things to increase the percentage of the voters they wanted in that district by 1.6%?
1.36%.
1.3%.
You're close enough. But
you had,
whether...
I'm sorry.
Yes.
You had 4 sophisticated experts, right?
Yes.
Is there any reason why one or more of them could not have drawn up an alternative map that met the legislature's stated partisan goal but had a different effect on the racial composition?
Because once again, we think that we proffered evidence that was as good as, if not comparable to, an alternative map.
But you admit they could have done that. It wouldn't have been a big burden for them to do that.
Well,
and they didn't do it.
That the legislative record reflects that the partisan justifications did not become clear until midway through trial. For most of the legislative session, most of discovery in the case, the enacted map was defended as being compliant with traditional redistricting principles.
I mean, this whole case is about disentangling race and politics, right? That's what the whole case is about.
But the justification for the map was largely based upon traditional redistricting principles until trial. Then at trial, the lead counsel says this was about partisanship. This was about, and the map creator says, I was instructed to make this a Republican-leaning district. And alternatively, it's traditional redistricting.
Sorry, I didn't mean to interrupt. Until trial, you thought that the state was going to defend this without making the argument that this was done to increase Republican chances in District 1?
Yes, Because
Really?
it was not in the guidelines for the legislature that they were achieving a political goal. There are statements that we have included in our brief that outline that people were disclaiming that this was about partisanship and this was about, but even—
You didn't see
even
that
if-
in the discovery? You had very extensive discovery.
There was people during—
They didn't say, the
it looks-
discovery doesn't, the members of the legislature in the discovery didn't say this is what our aim was?
If you look to the testimony of people like Mr. Fiffick, Mr. Torini, these are counsel for the staff, they were all disclaiming in the lead up to trial that this was about partisanship.
And in fact,
Let
I
me come
mean,
back
you
to
know
Dr.
the record better than I do, but is it a particular surprise that people did not brag about the fact that they were doing a partisan gerrymander?
And the court acknowledged that in its opinion.
Is it a
that-
surprise that instead they disclaimed that they were doing a partisan gerrymander until it got to the point where they thought we better make a case?
And we know that they were, notwithstanding looking at BVAP throughout the legislative process, they were running BVAP reports for every map, and they were looking at the connection between racial data and political data, and because they believe, whether they were right or wrong, whether they should have relied upon one piece of partisan data or not, they were relying upon race consistently to understand the ramifications politically for their map drawing.
did-
And they have
Robert,
no
also-
other reason.
Do you have evidence of that they were relying extensively on race?
Yes, we know that, again, they were looking at race as they, on the screen, seeing how it
Well, they
factored
had the
into
racial
BVAP,
data.
and seeing
Is
how
there
it
anything
affected the—
surprising about that?
And we don't have a problem with them looking at race data or being race conscious, but they had no good reason to do it, and again, they were disclaiming it.
But I thought counsel that needed to ensure compliance with the Voting Rights Act was asking Mr. Roberts for the racial data.
There's never been a defense that they were trying to draw CD1 in order to comply with the Voting Rights Act. They disclaimed that they were looking at race at all, and the court found non-credible that they were not looking at race. In fact, the experts tested, do the maps, are they more predictive based upon racial data and BVAP data than they are partisan data? They used the 2020 political data that the state said they only used. And Dr. Ragusa, corroborated by Dr. Amai, demonstrate that race was a better predictor than the only single piece of data that they had, that their consultant for the Senate was telling them was unreliable for predicting political behavior over time. These are all factual findings.
Dr. Amai
in
ran-
light of the record.
Why did they have so little electoral data? Because, I mean, it strikes me as like, if you were really using electoral data, why wouldn't you have more of it?
Well, they had more. In addition to the 2020 political data, they got the 2020, in the 2020 presidential data, they have the 2020 Senate data, but they've never advanced that they use that. The State Elections Commission is a defendant in this case, and they have tons of data, but they did not use it. And what the record reflects is that they were consistently looking at race because they had an expectation that race was a predictor for how political outcomes would perform. This is shown in the closing argument of counsel, my friend, who showed the connection between race and party in his closing, but he was relying upon racial reports and some partisan reports that were being generated during the legislative process. And once again, it is more than plausible that the court said in the total of evidence that the fact that there was this consistency in the BVAP, despite the fact that maps were changing over time. The House even tried to propose a map that was 20% BVAP, and Senator Kenson intervened, and then the House ultimately adopted a map with the BVAP. The National Republican Redistricting Trust was proposing maps around 17%. And in the colloquy with Mr. Roberts, the court asked, what would happen if you bring in VTDs or counties that maybe are not majority black but are below majority black? Would that affect the overall BVAP of your district? And he acknowledged that it would.
Well, when race and partisanship are so closely aligned, as they are, in fact, why is it surprising that a legislature that is pursuing a partisan goal would favor a map that turns out consistently to have the same BVAP?
Because if they're using race as the means to get there, this court last term said that a legitimate interest cannot be achieved with illegitimate
yeah,
interest.
if that's what they're using. But if they are disregarding race entirely and looking only at politics, where race and politics are so closely aligned, it isn't surprising that when you want to get a district that has a certain Republican percentage, you're going to get a district that has a steady BVAP.
Two responses to that. Even if the mapmaker wasn't just looking at race in the actual documents, the court credited that it was in his mind and that all the evidence reflects that they were looking at race. The fact that they were trying to keep it at 17% reflects that it had worked at 17% prior to 2018. It worked at 17% after 2018. They were defending this map as being least change, a map that had pre-cleared the Department of Justice, that had survived a constitutional challenge. And again, the lead sponsor said, we only wanted to make this a little bit more Republican leaning at trial. So they served their purpose, but at the heart of this, they served their purpose by focusing on the precincts with the highest VBAPs, leaving alone white precincts with in Charleston, and moving out black precincts.
What about West Ashley? Your opposing counsel mentioned West Ashley was moved out, so just give you a chance to respond to that.
West Ashley is cited by the court. This is a historic community that has a lot of mixed precincts, but what we see is that the entirety of—
It's predominantly white, isn't it?
It's predominantly white, but the precincts with the highest and most significant black populations, those were targeted for movement. And the court recognized that, yes, white voters may be overall impacted by this map, but because this is a white versus register reality on the ground look by this 3-judge panel, they recognized that there were some mixed precincts. There were white voters impacted, but the unrebutted expert evidence is that race was a better predictor for movement, and that black voters were significantly and disproportionately targeted for movement. And that is unrebutted by the state. The district court says they cannot explain the 30,000 Charlestonians moved out of CD1. They've never been able to explain that.
I'm sorry, did you want to finish your sentence?
They've never been able to explain that significant sorting, which complies with the question in Shaw.
Yeah, I think this goes to what Mr. Gore claims is a very serious flaw in Dr. Ragusa's methodology. And I want you to talk about that. Maybe you have a good answer to his argument. So let's say the Republican legislature is intent on ensuring that District 1 has a Republican lead. Then all else being equal, which of the following 2 precincts would they rather include in District 1? A district with a precinct with 3,000 residents that went 900 to 800 for Trump, 900 votes for President Trump, 800 votes for President Biden, or a precinct with the same number of residents, 3,000, that went 700 to 600 for Biden. 700 votes for President Biden, 600 for Trump. Which one would you rather include if you're a Republican legislature that wants to produce a Republican-leaning district?
I would like to know 2 things with respect to the racial makeup of those precincts, because here we know that the legislature knew not only the partisan performance based upon the 2020 data, but they knew the racial makeup.
Well, suppose you don't know anything. You don't know anything about race, which is what they claim. Not that they know any. They didn't take race into account at all. All you have before you are those statistics. 900 to 800 for Trump, 700 to 600 for Biden. You want to make it a Republican district. Which one do you want to keep in?
The former, but if this case would be more like Cromartie if they were actually looking at pure partisan data and they were looking at partisan data, voting behavior over time to make predictive
But that's
values.
the problem
That's not
with,
this
if I could
case.
just follow up, that is the problem they claim with Dr. Ragusa's methodology, because he says, no, you're going to, the one you want to keep is the one with the greater number of votes for President Biden. So you'd rather keep the district that went 900 to 800 for Trump because there are 800 Biden votes there, as opposed to the one that went 700 to 600 for Biden because there are fewer Biden votes there.
But Dr. Ragusa, in his rebuttal report, I think pages 3 through 4, controls for the precinct size, and notwithstanding controlling for that in his analysis, determines that black voters were moved out, white voters were kept in or moved in, and that is unrebutted data. So
what I just said is his methodology, is it not? He looked at the absolute number of votes for President Biden, not the percentage, not the net votes.
And Dr. Ragusa testified about why looking at the a total net was the better methodology than the percentages, and this was tested below, and the district court did not accept these arguments. And so this goes to, are we retrying expert testimony on appeal? Or do 3 judges, consistent with White v. Register, consistent with Cooper, are their findings of fact and credibility determined given the deference that an appellate court is to give a unanimous opinion, where in light of the total record, it reflects that there was a racial target. It reflects that there was a significant sorting of black people. It reflects unrebutted expert evidence of race rather than party explaining the assignment of voters. It reflects a disregard of traditional redistricting principles, and all of that evidence in total is more than plausible in the record for the using race as a means to harm individual plaintiffs, Mr. Taiwan Scott, and members of the South Carolina
Thank you,
NAACP.
Counsel. Justice
Your Honor.
Thomas? Justice Alito?
I'm concerned about what has been said here about Mr. Roberts. And as I asked Mr. Gore about that, is it not true that he has a long record working for the legislature, and he has drawn maps for both Republicans and Democrats?
Yes, the panel acknowledged he has 2 decades of experience in which he used race every time he was drawing maps in the past, but denied doing so in this case.
I mean, at trial, Judge Gergel, is that the correct pronunciation of his name? Gergel.
It is Judge Gergel, yes.
Judge Gergel had complimentary things to say about him. He said, I mean, I know Mr. Roberts. He's a very precise guy. What I want is if that report, he's talking about a particular report, isn't accurate, and I'm persuaded if he tells me it's not, that's good enough for me. It's complimentary of his honesty, right?
Yes, and also his honesty in footnote 9, I believe, where he recognized that a year after trial, Mr. Roberts was able to cite with specificity the racial makeup of VTDs, which was completely inconsistent with his non-credible denials that he did not look at race.
Okay, so then the district court turns around in its opinion and says that his testimony rings hollow. So that's a nice way of saying that he lied, right?
Yes, and that's what this court acknowledged was the case in Cooper.
It gave 3 reasons for it. And I want you to tell me which one of these is defensible. The third one is what you just mentioned, his in-depth knowledge of the racial demographics of South Carolina. Is that damning?
No, not in of itself, because race consciousness is not as the problem. It's the incredible denial despite all of the evidence, including his testimony, but also what the experts demonstrate, and also with the movement of so many people and just the coincidence that they land on the exact same BVAP.
All right, that's one. The second one is, Roberts failed to provide the court with any plausible explanation for the abandonment of his least change approach in drawing the Charleston County portions of congressional districts numbers 1 and 6, or the subordination of traditional districting principles, including maintenance of constituencies, minimizing divisions of counties, and avoidance of racial gerrymandering. So they say he gave no plausible explanation for that?
That's correct. In fact, Mr. Roberts admitted he abandoned the core priority of least change.
Didn't he say that he was aiming to produce a Republican district?
The court ultimately accepted that legitimate goal, Your Honor, but the court recognized in Cooper that using race as a means to get there is constitutionally suspect.
Isn't that a plausible explanation for all of those things?
The court heard the testimony, and that testimony was not as persuasive as the racial movements, as the expert testimony that, again, they have the opportunity to
The question is it a plausible reason? I mean, did they say, we don't believe Mr. Roberts because he had a shifty look on the stand, and this is a guy with a partisan background? Did they say anything like that? They gave 3 reasons.
No, Your Honor, it's plausible, but this court is not asked to look anew at the record, but to look at whether or not, in no circumstance would it be plausible that the outcome be what it is. And as a finding of fact, the court was correct.
All right, so and the last one is, he admitted that his movement of nearly 17,000 African Americans was inconsistent with the Clyburn staff plan for Charleston County that he claimed to be faithfully following. Right? Did he ever say, we followed exactly what Congressman Clyburn asked us to do? Did he ever say that?
The state makes a big defense that their map is consistent with what Senator Clyburn or Representative Clyburn was seeking. The amicus brief shows that that is not what the record actually reflects. And more importantly, what the court found was that Representative Clyburn's partial map did not treat the area of West Ashley, which was so critical to the VTDs that were moved out, that sorted voters on the basis of race. The partial map that Representative Clyburn put forward did not harm West Ashley in the same way.
Let me come back to the question I asked about why your experts did not produce an alternative map. Dr. Imai produced 10,000 maps, right?
Correct. For one simulation.
Yeah, he ran a simulation with 10,000 maps. He never considered politics.
As Dr. Imai's testimony reflects, that he tested for the criteria that the state was saying they were using in their guidelines, the objective criteria. And Dr. Imai and Dr. Duchin's methods are merely useful in this case as further support, as the district court recognized, to show that race was a significant factor in the design.
Well, in a case that's all about disentangling race and politics, how can we possibly give any weight to an expert report that did not take politics into account at all, purportedly?
The district court was confronted with that question and relied upon Dr. Imai's testimony for the findings that it thought were probative or not of the issue. But we do have the Dr. Ragusa and the Dr. Liu unrebutted testimony that did disentangle race, and that served the purpose of an alternative map, because we can look at figure 1 in the rebuttal report that Dr. Ragusa includes and look at the VTDs that were available to be moved in heavily white precincts that were available to be moved in, and those simply were not moved in. So they serve the same purpose as an alternative.
The defense expert, Ms. Sean Trendy or Trend, evaluated Dr. Ragusa's maps and found that Democrats would win District 1 in over 90% of the maps that Dr. Ragusa produced. Did Dr. Imai run a simulation using the political data as well, but then decide to shelve it when the results were not favorable to your client?
That is not what I believe the record reflects, Your Honor.
It just never occurred to him that politics might have something to do with this?
Every expert, as I believe Justice Kagan said, is being tasked with particular questions. I do not believe that there's any requirement that every expert look at every decision that one might go into a map. Each expert looks at different things. Dr. Ragusa and Dr. Ragusa and Dr. Liu served the purpose of disentangling and showing that race was more predictive than party affiliation. Dr. Imai and Dr. Duchin helped counter this narrative that this was a race-blind draw when all of the evidence demonstrates otherwise. And frankly, Dr. Duchin's testimony looked at all of the traditional redistricting principles. And I would submit that these were all raised pre-trial, and this is the type of, this is what trial courts are given the authority to do, not to have what is happening here, but is relitigating the validity of expert testimony that the court accepted.
All right, Dr. Imai did not control for politics. Did the district court rely on Dr. Liu?
The court did not specifically rely upon Dr. Liu, but his analyses as the amici of the political scientist who did the work in Cooper corroborate that he used the same methods that were faithful to Cooper, and his analyses substantiate Dr. Ragusa's and point in the same direction, that race was a better predictor than partisan.
Did Dr. Duchin control for politics?
She did in some of her analyses. If you look at one of her supplemental reports, she looked at how the maps would fare when you put particularly the candidates of choice of black voters on the map, and she determined that black candidates performed worse in the enacted map than generic partisan races, which are essentially white-on-white races. So that is one way that she looked at partisanship, but she did not do a disentangling method, if that is what you're getting at.
Okay, last question. I'm sorry to go on for so long. Did Dr. Liu and Dr. Ragusa use the county envelope method?
They both did, correct.
Is that a sound method?
It is. It's what Dr. Ansela Behair and Dr. Max Palmer used in Cooper and Bethune-Hill, respectively.
Under that method, if there are two people who live in the same apartment building, under the county envelope method, could one, does the analysis take into presume that one can be moved and the other can't? One could stay in a district and the other could move?
I do not believe that's the case because the county envelope method is relying upon precincts, and so it would not be at that level of detail.
Does it assume that that all precincts could be moved regardless of their location?
Only those within the county envelope, which is reflective of the fact that a county like Berkeley or a county like Beaufort was wholly moved into CD1. So it was fair for Dr. Ragusa and Dr. Amai to assume that any VTD in those counties could have been moved into CD1, and where we saw that they were not is where black voters were at issue.
Thank you.
Justice Sotomayor?
I understood the record the way you did, but I understood that Dr. Liu was asked to produce maps that were consistent with the traditional criteria that the state indicated it had used, correct?
That is correct, Your Honor.
So he never looked at partisanship because that wasn't one of the criteria that it at first said it had used.
That is correct, Your Honor.
So I know it seems strange, but as I understood the record, and I know Justice Alito thinks that it should have been assumed that partisanship would be the defense. Do you know if the answer in this case raised partisanship as a defense?
I do not believe so. Again, the legislature almost entirely predicated their line drawing during the legislative process on traditional redistricting
So you were relying on what they said during the process?
What they said, and this court has been skeptical when legislatures have come up with post hoc justifications. But what's important here is that the panel accepted their justification, presumed that they would not admit it, and then still allow plaintiffs to test whether that was the true reason behind the line drawing, and found that it was not. It was less.
So what your experts showed was that everything they said during the legislative process had to be race-based in some way, because that's what the evidence showed. They couldn't explain the large movement of blacks as opposed to whites, blacks as opposed to, or democratic whites and black. So they had to come up with a different reason for why they did what they did, correct?
There were indeed shifting reasons, and race as a means for a political goal is constitutionally suspect.
Thank you.
Justice Kagan? Justice Gorsuch? Justice Kavanaugh?
On the least change point that you mentioned, my understanding, but I want to get your understanding of the record, was that Senator Campson wanted Beaufort and Berkeley counties to be kept whole. He wanted a stronger Republican tilt, and he wanted Representative Clyburn to represent some of Charleston County because of Representative Clyburn's clout in the Congress and with the administration. So if those things are accurate, and I just want your understanding of the record, then doesn't that mean you couldn't draw the first district without some significant changes?
Those are generally the findings of the court, but the court recognized and detailed in its opinion that when Beaufort, when Berkeley, when Dorchester were brought in, they had black neighbors. And those black neighbors increased the BVAP in CD1 to a politically risky 20%, and black Charlestonians were offset. Black people were treated one-to-one, traded, one in, one out. White voters, the Republican-leaning ones, were individualized and allowed to come into CD1, and white Democrats were even kept in or individualized and allowed to remain in CD1. It's only black people in the design of this district that were treated with racial stereotyping, which is offensive to this, the Constitution.
Right, I understand that principle, of course, but West Ashley was predominantly white and predominantly Democratic, and then was moved out, right?
Yes, but there were significant, still heavily black precincts
Right.
that were moved out alongside of it. And the court addressed
Your point is
this
there's
matter.
a higher percentage of blacks than whites moved out.
Is
that right?
That is correct.
Because there were a lot of white people moved out of District 1
That is
West.
correct, and the court confronted the net effect argument in its opinion. And when you look at the paragraph about Deer Park, it talks about how you may have a precinct that has 10,000 white people in it and another precinct that has 8,500 black people in it. Still a minority, but still substantial. And the movement of those precincts would notwithstanding affect the overall BVAP of a district. And that's exactly what the court considered and confronted. This is not a new argument being raised. It was considered by the court and it was rejected in its racial gerrymandering finding.
And the other side makes a point that the original plan that came from Representative Clyburn's office actually had a lower black voting population for District 1 than what ultimately emerged. Just want to get your response to that, the relevance of that in the overall record.
I think it's irrelevant because I don't think that his map determined the sorting that was actually done by the key decision makers that the court acknowledged. But even more, if you look to the amici brief that Representative Clyburn's office offers in this case, they provided a partial map, and then from there the state drew out the partial map of one district, and from there drew out the other 6 districts. So we have no idea what the BVAP of CD1 would be based upon. What the record reflects, Representative Clyburn was seeking in CD6, and that is detailed in the amici brief that he submitted.
Yeah. Thank you.
Justice Barrett? Justice Jackson?
So I guess I'm still struggling with this clear error standard and the application in this context. Justice Alito asked a number of questions about the reasons that the district court highlighted for why it did not credit Mr. Roberts' testimony. And I guess consistent with what I understood the clear error standard to require of us, I didn't know that we were to evaluate whether we agreed or disagreed with each of their findings, whether we would have found, had a different takeaway from the fact that, his testimony, the district court said it rang hollow. If we thought it didn't ring hollow, would that be a basis for clear error? Do I not understand what the clear error standard is?
I don't believe that you do. I believe that the credibility determinations, the ability for the court, as in White v. Register, as in Cooper, to have listened to the witnesses is clearly given much deference by this court, that the racial gerrymandering finding is a clear error finding, and the subsidiary
right, and the subsidiary findings as well, so that if the district court said, we don't believe he gave a plausible explanation, and we look at it and we think the explanation is plausible, that distinction, the fact that we disagree with that particular subsidiary finding, is not the basis for clear error. Is that right?
That is my understanding. This is the total record.
So maybe you would have clear error if, for example, the district court didn't have any subsidiary findings. If they didn't say anything about Dr. Roberts, they just say, nothing, maybe. But in this case, they did have 3 reasons, right, why they didn't agree with him. So I guess I just want to be clear as to what we're looking at from the standpoint of clear error.
I think it's at least 3 reasons, and I think for why the court did not credit all of his reasons for why the map was drawn the way that they did. And it wasn't just that the court just listened to his testimony and said, I disagree with you, but that testimony did not align with the other facts in the record, which reflected that race predominance was occurring in this map, and that is overall a finding that's backed up not only by the unrebutted disentangling method, but is borne out by the state's own data.
All right, let me ask you about the hypothetical that Justice Alito put forward with respect to moving in 900 Trump voters versus, a district with 900 Trump voters and 600 Biden voters versus a district with 700 Biden voters and 600 Trump voters. I may have gotten that wrong, but I think his point was that if politics is at play, then clearly you'd want to bring in the district with more Trump voters if you are trying to get a Republican tilt, and I think that's right. But I guess what I am trying to understand is how the BVAP stays the same unless you're looking at race. So that if you bring in the district with the more Trump voters, the assumption I think that everybody seems to be operating under is that that district would likely have more white voters in it because race is correlating with politics. And if that's the case, then I would expect bringing that district in, the BVAP would drop. And yet here, it stayed the same, and I understood your argument to be because black voters elsewhere were moved out, that race was used to move out black voters when you brought in the 900 Trump voter district. Is that the point that you're making?
That is the point that I'm making.
And you're saying that that is the unlawful application of racial gerrymandering. So even though, as Justice Kavanaugh pointed out, the sort of overall BVAP remains the same, in a situation in which you're bringing in more white voters and moving out black voters in this kind of circumstance, you're still relying on race in a way that is, you say, improper.
Yes, correct, and I would only detail that not only are you moving in white voters, you're moving in black voters, and you're not just, and then for those black voters moved in, you're offsetting them by kicking out the black Charlestonians, and that's exactly what the court details in its opinion happened here, the race as the means to achieve this political goal. And I just want to acknowledge also that this is not, I mentioned at the onset, this is not the case of Cromartie, where this court said the plaintiffs failed to prove racial predominance because we see in the record that they were actually looking at voting behavior data. The record does not reflect, this is the inverse of that case, where the record reflects they were looking at racial data for its predictive purpose, and they were every once in a while looking at partisan data to see its connection, but they were relying upon race data, and they had no good reason to do that.
And as Justice Kagan said, we kind of think that your argument is that racial data was really kind of driving this because they didn't have a robust set of political data that they were drawing from in order to do this.
Because in their mind, they were using race as a proxy to predict partisan behavior.
Thank you.
That's what the record reflects.
Thank you, counsel.
Thank you, Your Honors.